I remember the sound the courtroom made when she said it. Not the gasp from the gallery, not the shuffle of papers from the attorneys. It was the silence, after that particular kind of silence that only happens when something has been said out loud that everyone in the room is now pretending not to have heard. My ex-wife, Carolyn, stood at the plaintiff's table in a pale blue blazer she had bought specifically for court, and she told the judge that I had spent the last 31 years of our marriage accomplishing absolutely nothing of any lasting value. I looked at my hands. They were steady. I noticed that, actually, the way you notice small, irrelevant things when the larger thing happening is too strange to process directly. My hands were completely steady on the table in front of me. I was 63 years old, and I had spent the better part of 4 decades building things that Carolyn had never once asked to see. So in a way, I thought, she was not entirely wrong. She had never seen what I had built. That part was accurate. What she did not know, what her attorney, a young man named Preston, who wore cufflinks shaped like gavels, they did not know, was what was inside the folder my attorney had set on the table in front of me 40 minutes earlier and had not yet opened. I will get to that folder. But first, let me tell you how we got to that room. I was 29 years old when I married Carolyn Whitfield at a church outside of Knoxville, Tennessee, on a Saturday in October when the leaves were at their absolute peak. She was beautiful and quick and funny, and she laughed at things I said before I had even finished saying them. I was working then as a materials engineer for a small firm outside of Nashville that designed load-bearing components for infrastructure projects. Roads, bridges, the kinds of unglamorous things that hold the world together without anyone ever thinking about them. That was the work. That was always the work. Carolyn taught second grade. She was extraordinarily good at it, the kind of teacher that children remember for the rest of their lives, the kind whose former students would stop her in grocery stores 20 years later and tell her what she had meant to them. I admired that about her completely, and without any reservation. It was a real gift, the way she could see a child and know exactly what that child needed to hear. She could not do that with me. I do not say that with bitterness. I want to be honest with you, because this story does not work if I am not honest. We were 2 people who loved each other in the early years, and then grew so far into our separate selves that by the time we understood the distance, it was wider than either of us knew how to cross. I came home late most nights. I ate dinner reheated, standing over the kitchen sink sometimes, reading notes I had made to myself in margins. Carolyn stopped asking about the work somewhere around year 8. I stopped telling her somewhere around year 10. The children we had 2, a daughter named Beth and a son named Marcus, grew up watching a father who was present in the house and absent in every other meaningful way, and a mother who was warm and patient with everyone except, increasingly, her husband. Beth will tell you now that she understood me better than Marcus did. Marcus, who is 31 and sells commercial real estate in Atlanta, has a theory that I was simply not built for family life. I think he is not entirely wrong. But I think the fuller truth is more complicated than that, and fuller truths usually are. Here is what was happening in the basement during those years. I had started a secondary project in 1997, entirely on my own time, using materials I purchased myself. It had come from a problem I had noticed at work, a specific failure pattern in the steel composite joints used in bridge deck panels, a weakness that only appeared under a particular combination of stress and temperature change that the existing models did not fully account for. The firm was not interested. They had contracts to fulfill and deadlines to meet and no budget for a junior engineer's theoretical side interest. So I worked on it at home. I built a small testing environment in one corner of the basement, between the water heater and the old chest freezer we had kept from Carolyn's parents' house. I worked on it for 4 years before I had something I believed in enough to document formally. I applied for the first patent in 2001. Carolyn was in the kitchen when I came upstairs and told her the application had been submitted. She was grading spelling tests. She looked up and asked if that was the bridge thing. I said yes. She said that was good, and then she went back to the tests. I stood in the doorway for a moment and then went back downstairs. The patent was granted in 2003. The firm I worked for had no claim to it. I had documented that carefully from the beginning, every material purchased with personal funds, every hour logged on nights and weekends, every note dated and witnessed. A structural engineer I had met at a conference in Memphis had been quietly advising me on the documentation process for 2 years by then, and he had been meticulous about it. The intellectual property was mine alone, clean and clear, and unambiguous. I left the firm in 2006 and licensed the technology to 3 civil engineering contractors, then 5, then 9. The royalty structure was modest at first. Then, the Federal Highway Administration updated its bridge inspection standards in 2009, following a series of high-profile infrastructure failures across the country that put the conversation about bridge integrity on front pages everywhere. Suddenly, the failure pattern I had been studying since 1997 was not a junior engineer's theoretical side interest. It was precisely the problem the industry had not known it needed to solve. By 2011, the licensing agreements were generating more income per year than I had earned in any 5-year period at the firm. I reinvested almost all of it. I funded a small research position at a civil engineering program at a state university in Tennessee. I partnered with 2 graduate students whose dissertations were adjacent to my original work. I established a scholarship for engineering students from rural counties in Appalachia because that is where I had come from, and I had needed something like that once, and it had not existed. I did not tell Carolyn about any of this in the kind of detail that would have made it real to her. I told her things were going well. She said that was good. I believe she thought I meant we were comfortable. We were. But comfortable was not quite the right word for what we were. Financially, by 2015, Carolyn filed for divorce in January of 2022. I was not surprised. We had been living in the same house in a way that felt more like 2 people sharing a long-term rental than a marriage. She was 61. She had retired from teaching the year before. She had friends, a garden, a book club that met on Tuesday evenings. She had built a life that fit her well, and I was not really in it. I was still working. I was still in the basement sometimes, or at the university, or on calls with contractors in 3 different time zones. She hired Preston. Preston had a firm in Nashville that specialized in high-asset divorce cases, and he was aggressive in the way that young attorneys who have never been wrong yet tend to be aggressive. He sent a discovery request within 2 weeks that was 63 pages long. He requested documentation of every financial instrument, every agreement, every entity I had ever formed. He was thorough. I will give him that. But thoroughness and understanding are different things. Preston looked at the licensing agreements and the royalty structures and the research endowment and the university partnership and the scholarship fund, and he constructed a theory. His theory was that Carolyn had supported this family for 31 years, had kept the household running, had raised the children, had maintained the social relationships and the community presence and the infrastructure of our daily life, while I had worked on a project that had become enormously valuable. His theory was that she was entitled to an equitable share of the ongoing royalty income, not just a division of accumulated assets, ongoing income in perpetuity. It was not an unreasonable theory, legally speaking. Equitable contribution arguments in long-term marriages have succeeded before. Preston was not inventing something frivolous. But there were several things Preston had not yet fully read. The hearing was in March, a Thursday, overcast, the kind of flat gray light that makes everything look a little more serious than it might otherwise. I wore the same suit I had worn to every important professional meeting I had attended for the past decade. Gray. Conservative. My attorney, a woman named Ruth, who had been practicing family law in Nashville for 35 years and who I trusted completely, had told me to let her do the talking. I intended to do exactly that. Carolyn sat at the plaintiff's table with Preston and did not look at me when we entered. I noticed that. Not with anger, with something more like recognition. She had been not looking at me for a long time. This was simply the formal version. Preston made his opening argument. He was polished and specific, and he used the phrase, "decades of sacrificial contribution," 3 times. He painted a picture of Carolyn as a woman who had given her prime working years to sustaining a family, while her husband pursued what he called, and I am not embellishing this, an obsessive private project of uncertain value. The judge, a woman named Honorable Patricia Norwood, who I later learned had an undergraduate degree in civil engineering before she went to law school, listened with her hands folded on the bench and her expression giving away nothing at all. Then Preston said it. He was building toward his argument about the royalty income, and he needed to establish, I suppose, that Carolyn had received insufficient recognition for her contributions during the marriage. And so he said, with the confidence of someone who had not done quite enough reading, that my ex-wife, had told him that I had spent 31 years in that basement and had never produced anything of lasting professional significance. That I had, in her assessment, and in her own words that he was now presenting to the court, never really amounted to anything. The courtroom was quiet. I looked at the judge. The judge looked at me. I noticed her expression shift, not dramatically, not in a way that Preston would have caught if he was watching. Just a small change around the eyes. Like something had come into focus. She said, slowly, "Counsel, before you continue, are you familiar with the work of Dr. Raymond Calvert?" Preston paused. He said he was not sure he understood the question. Judge Norwood said, "The gentleman sitting at the defense table, Raymond Calvert, are you familiar with his work?" There was a longer pause. Preston opened his laptop. I could see, from where I was sitting, that he was typing a name into a search engine. I had seen people do that before. At moments like this, the moment when they realize the room has shifted and they are not sure yet in which direction. His associate leaned over and looked at the screen with him. I watched the associate's face first, because she was less experienced at keeping her expression neutral. Her face changed before his did. Preston's hands, when he finally looked up from the laptop, were not steady in the way my hands had been steady an hour earlier. They moved in small, uncertain adjustments around the edges of the laptop, not quite gripping it, not quite letting go. Ruth set her hand lightly on my arm. I had not moved. Judge Norwood said, "Counsel, I'm going to give you a moment. Take the time you need." What was in my file was not a mystery to me. I had lived it, but I will tell you what Preston was reading, because you deserve to know what made a confident young attorney's hands lose their steadiness on a gray Thursday morning in a Nashville courtroom. There were 9 active licensing agreements, with contractors operating in 11 states, generating royalty income that had not decreased in a single year since 2009. There was the named fellowship at the university, the Calvert Fellowship in Infrastructure Engineering, which had funded 14 graduate students over 8 years, 4 of whom had gone on to their own published research. There was the endowment for the Rural Scholarship Fund, which had sent 31 students from Appalachian counties to engineering programs since 2013. 31. I had not planned that number. It was simply what the fund had supported by the time of the hearing. There was the keynote address I had given at the National Bridge Engineering Symposium in 2019, which the program had described in its materials as a foundational contribution to modern infrastructure failure analysis. There were 17 peer-reviewed publications. I am not a vain man about most things, but I will tell you that number, because Preston had told a federal judge that I had never amounted to anything, and I believe the record deserves to be stated plainly. There was a letter, included in the file at Ruth's suggestion, from the director of the Federal Highway Administration's Office of Infrastructure, which said, and I will not quote it exactly, because it is not my place to reproduce what someone else wrote, but the substance of it was that the methodology I had developed in that basement in Nashville had been incorporated into the revised national standards for bridge joint inspection that were now in use in 42 states. Preston read for a long time. The courtroom stayed quiet in the way that courtrooms stay quiet when something has happened that nobody is quite ready to respond to yet. When he finally looked up, Judge Norwood said, in a tone that was entirely professional and entirely without cruelty, "Counsel, I want to make sure the record reflects an accurate picture of what we are discussing today. Would you like to revise any characterizations made earlier in these proceedings?" Preston said he would like a brief recess. The judge granted it. I walked into the hallway with Ruth and stood by a window that looked out over a parking garage. Ruth said nothing for a moment. Then she said, "You could have told me the fellowship had 14 students. I only had 11 in my notes." I said I thought 11 was close enough. She looked at me for a moment in the way that people look at you when they are deciding whether you are being modest or whether something is wrong with you. Then she made a sound that was not quite a laugh. "I want to tell you something about those 31 years. Because I think there is a version of this story that wants to be about winning, about the moment of reversal, about the attorney's hands shaking, about the judge knowing my name, and I understand why. That moment happened. It was real. If I tell you it did not feel like anything, I would be lying to you. But the truer thing, the thing I have been sitting with since that Thursday in March, is that the winning had already happened. It had happened in 2003 when the first patent was granted. It had happened in 2009 when the revised failure models were adopted by 3 state transportation departments. It had happened every time one of the fellowship students sent me a paper they had published and asked if I had any notes. The courtroom was not where the work became real. The work had been real for a long time. The courtroom was simply where one other person found out. Carolyn's attorney did revise his argument after the recess. He no longer claimed she was owed a share of ongoing royalty income. That argument was quietly set aside. The final settlement addressed the marital assets accumulated over the marriage, the house, the retirement accounts, the savings, and divided them in a way that was equitable and that I did not contest. I did not contest any of it. That was not the point. The point, if there was one, is that you cannot successfully argue in court that a man never amounted to anything when the judge hearing your argument once studied the same field the man built his career in. Judge Norwood, Ruth told me afterward, had written her undergraduate senior thesis on bridge deck composite failure patterns. She had recognized my name from the revised federal standards. I did not know that going in. I had simply sat down and waited for the record to speak. Marcus called me that evening. He had heard from Beth, who had texted her mother, who had, I can only assume, called him in some form of distress. Marcus said, in the careful way he has always had, that he hoped things had gone okay today. I said they had gone fine. He said he was glad. There was a pause, and then he said, Dad, Beth said the judge knew who you were. I said that was right. He was quiet for a moment. Then he said, I didn't know that. About the fellowship and the standards. I didn't know all of that. I said I knew he didn't. He said, why didn't you tell us? That is a fair question. I have been thinking about it since. The honest answer is that I did not know how to make it real to people who were not inside it with me. The work was the work. It existed in technical language and measurement tolerances and the slow accumulation of data over years, and I did not know how to translate it into the kind of story that a family tells about itself at dinner. I should have learned. I think that is probably the thing I would do differently if there were a version of this where I got to try again. But there is not a version of this where I get to try again. There is only this version, where I am 63 years old and standing in a parking garage outside a courthouse in Nashville, while my son asks me on the phone why I never told him what I had spent my life doing. And I do not have a clean answer for him. I only have the honest one. I said, I didn't know you were asking. He said, I didn't know I needed to. We talked for a while longer than we usually do. I told him about the graduate students and the fellowship and the year the revised standards were adopted and what it had meant to me to come from a place where the bridges were old and underfunded and to spend my life making it less likely that they would fail. He listened in the way that I had not always given him the opportunity to listen. Before we hung up, he said he wanted to come up to Nashville next month and see what the basement workshop looked like. I said the chest freezer was still there. He said he didn't care about the freezer. I told him I would make dinner. I am not going to tell you that the courtroom was justice. Exactly. I do not think courts dispense justice the way we imagine when we are young and still believe in clean outcomes. I think courts dispense record. They put things into language and establish what can be officially said. What happened on that Thursday in March is now part of the official record of a Nashville court that Raymond Calvert, 63, materials engineer and patent holder and founder of a fellowship for infrastructure engineering, graduate students, and a scholarship fund for rural Appalachian kids who wanted to build things that man did not. In any language, the law recognizes, never amount to anything. That is on the record now. But the work was real before the record said so. The 14 fellowship students were already doing their own work. The 31 scholarship recipients were already in classrooms or labs or out in the field on bridge decks in Tennessee and Kentucky and West Virginia, doing the thing I had hoped they would do when I set the endowment up. The bridges that are safer because of the revised inspection standards are not safer because a judge in Nashville established on a Thursday that the man who helped develop them was not nobody. They were already safer. That had already happened. Preston was wrong about what he said, but I am not sure he was wrong about everything. Carolyn did keep the household together for 31 years in ways I did not adequately acknowledge or participate in. The children had a mother who showed up for them in ways I often did not. The dinners I ate standing over the sink were dinners she had made. The school events I missed were events she attended alone. That is also the record, and I am not going to ask for it to be set aside because a courtroom was impressed by my CV. I think, if I had to say what this story is about, it is not about winning. It is not about the attorney's hands, or the judge's expression, or the 42 states. It is about the gap between what you build and what the people who love you are able to see. I built real things. I should have built more bridges between the basement and the kitchen. I did not. I do not have a tidy resolution for that, friends. I only have next month, when Marcus comes to Nashville, and I make dinner, and I show him the corner where the water heater used to hum while I worked, and I try to explain, in language that is not technical, what it felt like to spend your life solving a problem that nobody thought was a problem yet. The only work that lasts is the work that was actually worth doing. I believe that was true before the courtroom, and I believe it now. I am going to go make sure the basement is clean before my son arrives.